Okay, so Christy Merrill here, founder of the Fraud Project. Bring it down, bring them home. Just for reference, this video is being made in reference to a question that I was asked, and it is a very, very valid and very important question. So the question was, if you have an ongoing CPS case in state courts, are you able to go ahead and file in federal court? Is there anything you can do if your case is ongoing? Okay, and I want to answer the question in a couple different ways. First of all, I want to read a couple of things to give you an idea of what fraud on the court, why it's federal subject matter jurisdiction, etc., what it means. So fraud on the court is where we are asking the federal government to literally get involved in giving us damages and stopping actions that are being taken against us, and we have to give them good legal reasons to do that. But fraud on the court, which is defined by like state actors colluding to make the judicial machinery of your entire case non-effective at all. Different examples again include judge acting in an absence of jurisdiction, the collusion of state actors, meaning attorneys, your own attorney not working, ineffective counsel, and working with the judge, CPS, GALs, whatever it is. That is what defines this fraud on the court. When the judicial machinery has been absolutely corrupted to the point that it does not work, so that it is completely null, a legal nullity, and the judgment that will be made is voidable because the case was a legal nullity in the first place, void ab initio. Like I said, that's your key framework for fraud on the court. All right. But I wanted to address the part where even if these cases are ongoing, there are multiple things that we can do. And I mean multiple things that we can do. And so one of those things is that we can go to federal court, file a fraud on the court complaint, which is what I'm trying to do with the Fraud Project, and we can ask for stays, injunctions, we can ask for extraordinary writs, we can ask for multiple things. And so the reason, and this is what everybody needs to research that has this question, the reason that we can do that is because of something called abstention doctrine. There are several different doctrines that have to be satisfied for your case to do that, to be taken in by the federal courts. And I know that this is a lot lately, but I'm working on these classes so that a 9-day module is what I'm working on, so that in 9 days you'll have a much better grasp of what we're doing here, enough to be able to write out your own federal fraud on the court, 1983 Manel complaint, etc. So anyway, so these abstention doctrines, basically what they say is that the federal court, because it doesn't want to cause conflict with the state courts, does not want to intervene except in certain instances, okay, except in certain instances, in state court, ongoing state court matters. Rooker-Feldman doctrine is a type of abstention doctrine that very clearly qualifies whether or not these federal courts are going to get involved in a state court judgment. And so let me just give you a little bit of an idea of what that means. Generally, the federal courts do not in any capacity want to get involved in any type of family or domestic relations cases. They want the states to be able to manage their own cases, of course, obviously. But Rooker-Feldman very clearly outlines that in certain cases, and one more time, example of fraud, right? Fraud on the court, where the different actors, state actors, are colluding against a person and have corrupted the judicial machinery. That is a case where whether the case is ongoing or whether it is finished, adjudicated with a final judgment, the federal courts will get involved. I know this is going to sound bad, but our constitutional rights are not just enough by themselves to prove when they've been violated, that's enough for the federal courts to get involved. The abstention doctrines say that unless Congress has given permission, or there's a already understood inherent reason why federal court gets involved, they're not going to get involved. And in this case, I need everybody to know, when there is a case of fraud on court, collusion, RICO, racketeering, when there is Monell, 1983, familiarize yourself with that case. You need to understand Marbury versus Madison. That's another one you need to look up. The Younger abstention doctrine directly addresses whether or not it actually is a case that talks about how the federal courts cannot get involved. And we are going to assert in all of our cases, including the ongoing CPS cases, that yes, the Younger abstention doctrine does not apply. So yes, the federal courts can get involved, once again, based on the fraud. And so I want everybody to know that's your basic answer, okay? Your very, very basic answer. And I'm going to have a much more definitive answer when I do these teaching modules for you to understand. The basic answer is, even if you have an ongoing CPS case, I'm going to address one more thing. You have children that have been adopted out. Yes. Okay. So fraud on the court. Let me explain something to you real quick. The reason the federal courts are able to get involved is because of the corruption of the judicial machinery against you. Okay. The judicial machinery, when you're dealing with different actors colluding against you to create the case, which is the case in most CPS related cases anymore, then it has the right to intervene. And I want to let everybody know that based on the fact that none of the judicial machinery in the counties is working anymore, the point of the Fraud Project, one more time, is that we all file these fraud cases federally as soon as we can. Now, we have, as I said, for people that need comfort that have ongoing CPS cases, we have several remedies that we're going to place into our federal fraud on the court cases. And those remedies include extraordinary writs, mandamus, prohibition, okay, are the two biggest ones. We have also got the ability, I want us all to ask the judge to refer when there's a federal finding made by a federal judge of fraud, right? In our cases, we're going to ask him to the judge, to refer us to whatever agency necessary, DOJ, bar, everything, okay? But an injunction, which will stop all state proceedings until the time the federal judge makes a finding, in our case, in our complaints, our federal fraud on the court complaints. That is why we are able, just to answer the question, even if we have an ongoing CPS case, to go ahead and have the federal government be involved. But anyway, I hope everybody has a good day, and I hope this gives a basic, brief answer to your question.